An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. McDonald v. City of Chicago, 2010. In District of Columbia versus Heller, the Supreme Court held
that the Second Amendment protects an individual right to keep and bear arms in the home for purposes of self-defense.
However, Heller only concerned whether the Second Amendment restricts federal gun control laws.
Heller did not decide whether the Second Amendment applies to the states.
Immediately after Heller was decided, Otis McDonald and other Chicago residents challenged
ordinances that effectively ban handgun possession by virtually all private persons in the city.
I'm Otis McDonald, and I'm 77 years old. And to go down there and then they say, no, you can't have a handgun. I just wanted to protect myself and my family and my property.
Barron versus Baltimore held that
the provisions of the Bill of Rights originally applied only to the federal government.
However,
after the Civil War, the ratification of the 13th, 14th, and 15th Amendments changed the relationship between the federal government and the states.
In particular,
at the time of the ratification of the 14th Amendment, there were those who thought that the phrase privileges or immunities of citizens of the United States protected all of the rights guaranteed by the Bill of Rights.
Justice Alito added,
and there are prominent scholars today who continue to hold that view.
Professor Blackman and I both hold that view. However, the Supreme Court rejected that view in two important decisions. First, in the slaughterhouse cases, the Supreme Court gave the Privileges or Immunities Clause
a very narrow interpretation.
Specifically, the majority held that the clause did not protect an unenumerated right to contract. Second, in United States versus Cruikshank, the court held that the Privileges or Immunities Clause did not protect enumerated rights, such as the First and Second Amendments. To compensate for the deleted Privileges or Immunities Clause, the Supreme Court would gradually expand the scopes of the Due Process and Equal Protection Clauses beyond their original meaning. In the late 19th and early 20th century, the court began to hold that the provisions of the Bill of Rights were
protected against abridgment by the states under the Due Process Clause of the 14th Amendment.
Under the doctrine of selective incorporation,
the court incorporated provisions of the Bill of Rights one by one rather than all at once.
By 2010, the court had
incorporated virtually all of the rights in the Bill of Rights under the Due Process Clause.
However, the Second Amendment had not yet been incorporated. Study Guide: How does the court decide whether the Second Amendment is a fundamental right? Former Solicitor General Paul Clement represented the National Rifle Association as a friend of the court. He argued that the Second Amendment was a fundamental right and was therefore incorporated by the Due Process Clause of the 14th Amendment.
That whatever the debates about substantive due process when it comes to unenumerated rights, that the textual provisions of the Bill of Rights stand in a favored position with respect to incorporation.
4 members of the court agreed: Justice Alito, joined by Chief Justice Roberts, Justice Scalia, and Justice Kennedy.
We analyze the question presented here under the Due Process Clause. That is, the practice that the court has followed now for more than a century, and we continue on that path. And we hold that the Heller right easily meets the standard that the court has used during the last half-century.
Why was the right fundamental? Justice Alito invoked the Washington v. Glucksberg approach to identifying fundamental rights.
The right to keep and bear arms is implicit in our understanding of ordered liberty and is deeply rooted in the traditions of our country. Heller thoroughly explored the origins of the right and showed that it was considered fundamental by those who drafted and ratified the Bill of Rights.
Justice Alito continued,
This understanding continued during the early years of the Republic when many states adopted constitutional provisions protecting the right to keep and bear arms.
Justice Breyer, joined by Justices Ginsburg and Sotomayor, dissented. They contended that the right to keep and bear arms was not fundamental.
Conclusion. 1. The framers did not write the Second Amendment in order to protect a private right of armed self-defense. 2. There is no consensus that the right is or was fundamental. 3. No broader constitutional interest or principle supports legal treatment of that right as fundamental. 4. Incorporation is difficult to reconcile with the Constitution's allocation of responsibilities between states and the federal government, between courts and legislatures. And 5. Nothing in 18th, 19th, 20th, or 21st century history shows an unambiguous historical consensus that the right is sufficiently fundamental as to warrant incorporation. In our view, Heller or no Heller, the 14th Amendment does not incorporate a private right of armed self-defense and apply that right against the states.
Neither the conservative plurality nor the more liberal dissenters were willing to reconsider the slaughterhouse cases. During oral argument, Alan Gura, McDonald's lawyer, contended that the right to keep and bear arms was among the privileges or immunities of citizens of the United States. To this, Chief Justice Roberts replied,
Of course, this argument is contrary to the slaughterhouse cases, which have been the law for 140 years. It might be simpler, but it's a heavy burden for you to carry to suggest that we ought to overrule that decision.
Likewise, the self-professed originalist Justice Scalia challenged Gura's reliance on the original meaning of the Privileges or Immunities Clause.
Why are you asking us to overrule 150, 140 years of prior law when you can reach your result under substantive due process, unless you're bucking for a place on some law school faculty?
No, I've left law school some time ago, and this is not an attempt to
I mean, what you argue is the darling of the professoriate, for sure, but it's also contrary to 140 years of our jurisprudence. Why do you want to undertake that burden instead of just arguing substantive due process, which, as much as I think it's wrong, I have acquiesced in it?
Your Honor, the slaughterhouse cases should not have any stare decisis effect before the Court. The Court has always found that when a case is extremely wrong, when there is a great consensus that it was simply not decided correctly, especially any constitutional matter, it has less force.
Ultimately, a four-justice plurality used modern substantive due process doctrine to apply the right to keep and bear arms to the states via the Due Process Clause of the 14th Amendment. Chief Justice Roberts and Justices Alito, Scalia, and Kennedy. Only Justice Thomas was willing to rely on the Privileges or Immunities Clause of the 14th Amendment.
I have filed an opinion setting out the judgment of the Court. Justice Thomas joins that opinion in part, but he has also filed a concurring opinion explaining that he would hold that the right to keep and bear arms is one of the privileges or immunities of national citizenship.
Justice Thomas found that the Privileges or Immunities Clause originally, quote, was understood to enforce constitutionally declared rights against the states. What were these rights? Justice Alito acknowledged the history that preceded the 14th Amendment.
Evidence from the Civil War period is particularly instructive. When the Civil War ended, soldiers in the Union Army were allowed to keep their rifles when they returned home. More than 180,000 African Americans served in the Union Army, and when they returned home, often to the states of the old Confederacy, systematic efforts were made to disarm them and other blacks. Armed parties, often consisting of ex-Confederate soldiers serving in the state militias, forcibly took firearms from newly freed slaves and other blacks. The Reconstruction-era Congress was alarmed by these practices. Union Army commanders tried to stop these abuses by issuing orders securing the right of all people to keep and bear arms, but Congress decided that more was needed. It first turned to ordinary legislation. It enacted the Freedmen's Bureau Act of 1866, which explicitly guaranteed the right of all citizens, quote, to have the full and equal benefit of the constitutional right to bear arms. The Civil Rights Act of 1866 had a similar aim, but Congress feared that these civil rights laws would be held to exceed Congress's power, and Congress then proposed the 14th Amendment, which was ratified.
Justice Thomas found that this history points, quote, unambiguously toward the conclusion that the Privileges or Immunities Clause enforces at least those fundamental rights enumerated in the Constitution against the states, including the Second Amendment right to keep and bear arms. Additionally, he found that the, quote, ratifying public understood the Privileges or Immunities Clause to protect constitutionally enumerated rights, including the right to keep and bear arms. As a result, Justice Thomas would have overruled Slaughterhouse as well as Cruikshank. This precedent, he wrote, is not, quote, entitled to any respect. In conclusion, Justice Thomas found that the right to keep and bear arms applies to the states, and therefore he cast the critical fifth vote to declare unconstitutional Chicago's ordinances. Why were 8 justices unwilling to overrule Slaughterhouse? We believe that they were afraid of opening up a Pandora's box. Both the liberal and conservative justices were concerned about protecting unenumerated rights. Justice Kennedy asked,
what are these other unenumerated rights?
Likewise, Justice Ginsburg asked,
what unenumerated rights would we be declaring privileges and immunities under your conception of it?
Attorney Alan Gura answered that
we have wonderful historical guideposts.
For example, he looked to
the sort of right that was mentioned in the Civil Rights Act of 1866.
That statute protected the rights.
They listed to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property. In 1868, the right to keep and bear arms was understood to be a privilege or immunity of citizenship.
However, Justice Ginsburg expressed concerns that the original meaning of this clause would not protect the rights of women. She asked,
did married women at that time across the nation have the right to contract, to hold property, to sue and be sued?
The conservative justices were also concerned about what other rights might be protected by the original meaning of the Privileges or Immunities Clause. In what seemed like a veiled reference to Lochner v. New York, Justice Alito asked,
well, does it include the right to contract?
Chief Justice Roberts expressed concern about increasing judicial discretion to find unenumerated rights.
Your original approach would give judges a lot more power and flexibility in determining what rights they think are a good idea than they have now with the constraints of the Due Process Clause.
Justice Thomas was not troubled about protecting unenumerated rights with the Privileges or Immunities Clause. As he wrote in his concurring opinion, quote, I see no reason to assume that such hazards apply to the Privileges or Immunities Clause. The mere fact that the clause does not expressly list the rights it protects does not render it incapable of principled judicial application. Why was there no special risk? He answered, quote, when the inquiry focuses on what the ratifying era understood the Privileges or Immunities Clause to mean, interpreting it should be no more hazardous than interpreting these other constitutional provisions by using the same approach. Determining the original public meaning of the Privileges or Immunities Clause, he wrote, is, quote, far more likely to yield discernible answers than the substantive due process questions the Court has for years created on its own with neither textual nor historical support.
When I heard Justice Thomas's reading and how far-reaching back that it went, it was really, really touching. And my mother and father would have been proud of me.
In the end, 5 justices found that
the right recognized in Heller is fully applicable to the states,
and Chicago's ordinances were unconstitutional. But the Court did not provide any more guidance on the scope of the rights protected by the Second Amendment.
As Heller noted, this right is not unlimited. Heller held that the particular ordinances at issue in that case violated the Second Amendment, but the holding went no further.
And neither did the Court in McDonald.